Hello friends, I am Advocate Sudip Patra, practicing in the Calcutta High Court and the Metropolitan Magistrate Court of Calcutta, which is also famously known as Bankshall Court. Today I want to talk to you about something that is causing a lot of panic among people right now, and that is receiving a notice or a summons in a check bounce case filed before the Metropolitan Magistrate Court in Kolkata. If you are sitting in Delhi, Mumbai, Bangalore, Chennai, or anywhere in India, and you have received a notice from a Kolkata court in a check bounce matter, this video is specifically for you. The first thing that happens after a check bounce complaint is filed before the Metropolitan Magistrate Court, Kolkata, also known as Bankshall Court, is that the court issues what is called a Pre-Cognizance notice. Now many people panic when they receive this notice. They do not understand what it means. Let me explain it simply. Under Section 223 of the Bharatiya Nagarik Suraksha Sanhita, the new BNSS, which replaced the old CRPC, before the magistrate formally takes cognizance of the case, a notice is issued to you as the accused. This is your first opportunity to appear before the court and make your submissions. This is actually a very important stage, and a good lawyer can use this stage effectively to present your side of the matter before the case formally begins. Do not ignore this notice. If you ignore it, the court will proceed against you without hearing your side, and things escalate very quickly from there. At Patra's Law Chambers, we appear at this pre-cognizance stage on your behalf. We study the complaint, we study the demand notice, and we immediately identify whether there are any technical or legal defects in the case against you. Once cognizance is taken and summons is issued, you are required to appear before the Metropolitan Magistrate Court. Now here is something many people do not know. A check bounce case under Section 138 of the Negotiable Instruments Act is a bailable offence. That means you are entitled to bail as a matter of right, but you still need to formally apply for bail and appear before the court. For clients who are located outside Kolkata, in other cities or other states, we file a bail application. We appear before the Metropolitan Magistrate on your behalf for the initial stages. And wherever applicable under the BNSS provisions, we explore the option of video conferencing appearance so that you do not necessarily have to travel to Kolkata for every single hearing. We have handled bail matters for clients from across India, from Maharashtra, from Karnataka, from Uttar Pradesh, who have had cases filed against them in Kolkata by banks and NBFCs that are headquartered here. The bail process in check bounce matters before the Bankshall Court is something we handle routinely, swiftly, and without unnecessary delay. After bail, the next stage is the recording of plea. The magistrate formally reads out the complaint to you and asks whether you plead guilty or not guilty. In almost all contested cases, the plea is not guilty and the matter then proceeds to summary trial. Under the Supreme Court's latest 2025 directions, check bounce cases are now being pushed through summary trial procedure for faster disposal. What this means for you is that the trial moves quicker than it used to, which is actually an advantage when you have strong defenses, because a faster trial means faster resolution. At the summary trial stage, the complainant presents their evidence, the check, the bank return memo, the demand notice, proof of service. Our job as your lawyers is to rigorously cross-examine the complainant's witnesses and systematically challenge every element of their case. Now this is the part I really want you to understand, because this is where many check bounce cases actually fall apart for the complainant. There are numerous grounds on which check bounce cases get dismissed. Let me tell you the most important ones. 1. The demand notice was defective. If the notice was not sent to the correct address, did not mention the correct check amount, or was sent after the 30-day limitation period from the date of dishonor, the entire case fails at the root. 2. The check was given as security and not in discharge of a legally enforceable debt. This is one of the strongest defenses available, and courts have consistently held that a security check which was not meant to be presented cannot form the basis of a Section 138 prosecution. 3. The complaint was filed outside the limitation period. If the complainant did not file the complaint within 1 month of the cause of action arising, the case is time barred. 4. The check was presented beyond its validity period of 3 months. A stale check cannot be the subject of a Section 138 case. 5. The legal notice was not properly served or was not received by the accused. Without valid service of the demand notice, the cause of action itself does not arise. 6. In ECS bounce and EMI bounce cases under Section 25 of the Payment and Settlement Systems Act, the mandate was not signed or was revoked, which completely changes the legal position. In my experience, before the Metropolitan Magistrate Court and the Calcutta High Court, a significant number of check bounce cases, particularly those filed by banks and NBFCs against borrowers, have technical and legal defects that, when properly argued, result in acquittal or dismissal. This is why having an experienced lawyer who knows this court and knows this law is not a luxury. It is the difference between conviction and acquittal. So to summarize, if you have received a pre-cognizance notice, a summons or a warrant in a check bounce case or an ECS bounce case filed before the Metropolitan Magistrate Court, Kolkata, here is what you need to do. Call us immediately. Do not wait. Do not ignore the notice. Patra's Law Chambers is located at Nico House, 2 Hari Street, Kolkata, walking distance from the Bankshall Court. We handle check bounce matters at every stage, from the pre-cognizance notice all the way to the Calcutta High Court and the Supreme Court of India if required.